Good afternoon, everybody. I want to personally thank you for being here and participating in our seminar today, both to the people that were able to appear in person and the people that are participating via webinar. Our job is always to make your job easier, so the information that we're providing you with here today, we're hoping you can use on a daily basis to make your ability to evaluate your claims easier and less frustrating. I am going to be talking about the recoverable medical specials. You might say, what's so important about recoverable medical specials?
What's so important about recoverable medical specials?
Thank you, Mr. Flynn. I am going to tell you. The single most important factor in determining what a jury is going to award in a verdict is the amount of recoverable medical specials. That's because the amount of past medical specials is used as a basis for determining future medical specials and also for determining general damages. Generally, what plaintiffs' attorneys will do at the time of trial is they will try to blackboard the highest number they possibly can and will try to put as many medical expenses as they can on the board, and then they will tell the jury, in association with awarding general damages for pain and suffering, you just need to double that number or triple that number if they're particularly brave, maybe say 4 to 5 times that number. And they do that because it is important to simplify things for the jury. But for me, the amount a treatment might cost often has nothing to do with the pain and suffering associated with that treatment. For example, if you have a fractured coxswain or a fractured collarbone, that hurts, and it takes you a long time to recover, but you might only have 5 doctor visits and not diagnostic testing or something that would be very expensive, versus maybe a diagnostic MRI where you essentially lie there and go through the machine. But the expenses for treatment for the broken coxswain or the fractured coxswain and the expenses for undergoing an MRI are comparable, even though the pain and suffering for those two things are not comparable at all. But in any event, that's what plaintiffs' attorneys usually do, is say, please go award 2 to 3 times the amount of the recoverable medical specials. Imagine a situation where what's been paid for medical treatment that's associated with the injury caused by the accident is $300,000. The medical facility charges $300,000, but what's been paid for the medical treatment is $100,000. Plaintiff's counsel, if he uses the 2 to 3 times rule, the plaintiff may recover $300,000 to $400,000 in the case where the jury is told the reasonable value of medical treatment is $100,000, because they'll award the $100,000 and then maybe another $200,000 or $300,000 if there's no future medical costs. So the verdict range in that type of case will be $300,000 to $400,000. But if the plaintiff is allowed to admit into evidence the billed amount, $300,000, and the jury accepts that as the reasonable amount, then you're looking at a jury verdict in the $900,000 to $1.2 million range. So that's why determining what these numbers are and trying to get them as low as you possibly can is very important in handling personal injury actions. The rule that applies, what the jury is instructed, is that to recover damages for past medical expenses, the plaintiff has to prove the reasonable cost of reasonably necessary medical care he or she has received. There's 2 components to the jury instruction. The cost has to be reasonable, but it also has to be related to the accident. The medical treatment must have been necessitated by the injury that was caused by the accident. So, for example, in cases that I've dealt with Nicole Findleton of Travelers, we had a gentleman who was involved in an accident and decided the insurance company should be paying for his massage therapy treatment that he received 3 times a week and his personal training. But that treatment, we argued, was not necessitated by any injury he might have suffered as a result of the accident he was involved in. In regard to future medical specials, the plaintiff again has the burden of proof, and he has to prove the reasonable cost of reasonably necessary medical care that the plaintiff is reasonably certain to need in the future. Reasonable incurred are the 2 elements. The highest number that a plaintiff should be able to recover is the reasonable value of the medical treatment. If somehow his loss is actually less than the reasonable value, then he's only entitled to the lowest amount. So you've got reasonable value, and the amount that's been incurred, it's going to be whichever of those figures is the lowest. Reasonable compensation for medical expenses can exceed what may have been paid by a collateral source. And you may ask, what is a collateral source? And I have the answer for you. The collateral source is basically medical benefits that a plaintiff receives from a source wholly independent of the defendant. This would be private health insurance, accident insurance, Social Security and disability benefits, things of that sort that are where the plaintiff receives benefits, but it has nothing to do with the defendant. If a payment, and the reason why we don't essentially punish a plaintiff by deducting the amount they're able to recover because they have health insurance is we want people to buy health insurance. We don't want them to say, oh, I'm not going to buy health insurance because I might be involved in an accident and I want to get higher damages. We want to encourage people to get health insurance, and we want to make sure that victims are made whole. Collateral sources payments only relate to things that are wholly independent of the defendant. So if somehow there's a med pay policy in your policy and you guys pay it out, and that's essentially where if you're involved in an accident and there's a med pay provision, the plaintiff automatically gets that amount. It's usually pretty limited, usually about $5,000 to $10,000. But assuming the plaintiff asks for that within the period of time in the policy, usually it's about a year, then that gets paid to the plaintiff, but that is not considered a collateral source. So that should be deducted from any recovery the plaintiff might ultimately receive. Another situation is the joint tortfeasor situation. We have a case wherein we're defending Uber, and essentially someone that was using Uber's application was on the way to pick up a passenger and got involved in an accident. The driver of the vehicle has already settled out, paid a pretty significant sum to settle out of the case. They're not letting Uber out. They're fighting over the whole issue about whether the driver can be considered an employee or an independent contractor. But the fact is, any figure that might, at some point down the road, be entered against Uber, the amount that's already been paid by the person that we may be considered vicariously liable for, that amount will be deducted before we're going to have to pay anything out of our own pocket. Another kind of odd situation is they consider that if something's been gratuitously written off, that is considered a collateral source and the plaintiff isn't penalized. But what gratuitously written off means is somewhat difficult to determine. Usually I consider that to be kind of like a charitable write-off. Like if it's the local doctor and he's like, oh, you can't afford this, I'm not going to charge you for the treatment I'm providing you with. It should not be considered gratuitous if a hospital decides we're never going to collect from this guy, so we're writing it off. Usually it says written off or adjusted or something to that fact. I don't think that should be considered collateral source, but I know many plaintiffs' attorneys try to turn that into a situation where it's a gratuitous payoff. Okay. I'm now going to talk about kind of the different factual situations that exist and how medical specials are determined. The first situation is private insurance, and this is kind of what started off the whole, all of the decisions regarding recoverable medical expenses. Because what the plaintiffs used to do is just essentially admit the bill. But the bill, they soon found out, had often nothing to do with the cost of the treatment that was provided. And the bill would vary between different counties and between different providers and would often depend on who was receiving the treatment. If the patient was paying cash, they might have to pay less. Or if the person was uninsured, they might pay less. So basically, a bill has no reflection on what the value of the treatment is. And what the initial case determined was that if there is a plaintiff who has insurance, private insurance, and the insurer pays the medical facility less than the actual billed amount, then the plaintiff is limited to whatever the health insurance company paid the facility, the medical facility. And any difference between what was billed and what was actually accepted, that doesn't go to the plaintiff. The plaintiff does not get that benefit because it's not compensating them for any loss because they're not financially responsible for paying the difference. Once the insurance company has paid the hospital, they're off the hook. Another situation where there is a collateral benefit either through Medi-Cal or Medicaid. Usually those guys often pay like a third less than what's actually the full amount on the bill. So if a plaintiff has received medical treatment through Medi-Cal or Medicaid, they don't get that full billed amount. They only get the amount that Medi-Cal or Medicaid paid, and often that's like a third of the billed amount. A similar situation is the workers' comp case. Workers' comp providers, medical providers often bill at a much lower rate than other providers. So we are entitled, the damages are limited to whatever the workers' comp providers have been compensated for the services that they provide. Where it gets tricky is if you have an uninsured plaintiff with unpaid bills, because then you don't have a payment. There's nothing that's been incurred. So with an uninsured plaintiff, you're looking at something called the reasonable value of medical services provided. And this gets a little tricky. You do need expert testimony. And essentially what we do, we often use a registered nurse named Tammy Rockholt, who does a great job. And she essentially, there's a number of sources or authorities you can look at and say, okay, how much does this back surgery usually cost? Or how much does Medicaid or Medi-Cal pay for this type of surgery? And they look at the treatment that's been provided, and they determine, and not necessarily whether it was necessary, but they determine whether it can be billed for and how much should have been, what the value of that services was. So Tammy Rockholt will essentially do an audit of the medical bills, and her figures usually come out about a third below what is billed. So that's always very helpful to have her around. The plaintiffs, recent case law has shown that the plaintiffs can't just introduce the bill. They have to show that the bill is reflective of the reasonable value of medical treatment that's been received. And that was actually a recent case. The Bermudez case just came out in June of this year. So you can't just stick a bill in front of the jury. You've got to have someone testify that it's reflective of reasonable value. The other situation that's been unresolved for quite a while is when there's a medical lien. And in the Katazinski versus Perry case, essentially what happened is the plaintiff received treatment, the hospital had a lien for the full amount, a third-party company came in and purchased that lien for a lesser amount, but the plaintiff was still on the hook for the full amount. In that situation, the plaintiff has essentially incurred the full amount of the bill because they're still on the hook for the full amount of the bill, and you were not allowed to bring in the amount that the financing company had paid to the medical facility. Another situation, sometimes I know you guys deal with government entities, and when there's a government entity involved, we kind of go back to how it used to be done years and years ago, where it's very complicated, where the plaintiff brings in the billed amount, and then you have a post-trial hearing where that amount is reduced by the amount that essentially wasn't paid. So under the government code, that's essentially solidified for them, that they do have the ability to do that. So when you've got a government entity, they can do discovery on what collateral sources the plaintiff might have. So just know the rules are a little different for any government entity defendant. Now, in association with discovering the amount recoverable, you need to go ahead and serve those form interrogatories and check the little box that says who's provided you with treatment, describe the treatment, what was paid for and I think it says actually the amount charged. So that's usually not going to give you the amount that was actually paid, so you need to follow up with special interrogatories and make sure you ask them to identify each provider and what was actually paid to that provider for the treatment provided. You also need to ask if there's any lien agreements out there to find out if there is a lien. In a request for production of documents, you want to ask for any health insurance policy they have. You want to ask for their health insurance card. A lot of times what we do is we actually go to their health insurance company and we can find out what was billed and what kind of treatment that they've received. You need to subpoena the medical records and billings. Don't assume the plaintiff is going to give you all of the medical records or all of the billings and all documents reflecting what was actually paid, because they're not going to do that. You need to go ahead and subpoena the medical records, and then usually there's a separate billing company and you need to subpoena those documents from the billing company. It's also important to know about any lien agreements that are out there. We have a situation, it's a case wherein the plaintiff's attorney referred the injured person to a medical provider, even though the plaintiff had coverage through Kaiser. And he did that, and there's no other reason except that he would have a higher bill at the end of the day, and he'd be able to put that on the board and say this gentleman's incurred, and what ended up being like $280,000. But then later on, the lien company only ended up paying like $70,000 for the treatment that was received. So we're still battling that issue, a year down the road. So you need to know who's paid the medical bills, in addition to what the amount of the medical bills are. As I indicated, you do need to retain an expert to talk about the reasonable value of services. You're probably going to need to depose the medical providers so you can confirm that this treatment was related to the accident as opposed to some pre-existing condition. You're going to need to depose the experts. Sometimes what happens, the law is a little murky on whether a medical provider can testify to reasonable value of medical treatment received, because the fact is most doctors don't do their own bills. They have somebody else do the bills, and they don't know how much it would cost or how much they're billing for a certain type of procedure. So it's important when you take a medical provider's deposition to ask them, hey, do you have any training in this? Do you know what the market rate is for this type of surgery? Because usually they say no, 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 and that way the plaintiff's counsel is forced to hire an expert and not just depend on a medical provider to give that number at the time of trial. So evidence at the time of trial to show the amount of past medical expenses. You can show the amount that's actually incurred or paid. And then generally what happens is you can tell them what amount was actually paid, but you can't tell them it was an insurance company that paid the money, because of course we all know that the existence of insurance or the fact that anybody has insurance at the time of trial is inadmissible. Excuse me, no, it's not. Future medicals, it can be a little trickier. An expert has to testify on behalf of the plaintiff to say that there is a need for future treatment, that it's reasonably certain they're going to need that treatment. He must talk about the probable cost of the treatment. They often have an economist discuss the effect of inflation on the cost, that they're only going to increase. And of course, the defense is going to want an economist to talk about present cash value, and that essentially means that if they say, future treatment's going to be $500,000, that all we have to do is give them $425,000 now, because $425,000 invested today will increase to $500,000 down the road. So you do need an economist to talk about present cash value. In addition, if they are claiming the plaintiff needs a lifelong care, for example, if someone, maybe they're in a vegetative state, because there is something in the jury instructions which says, okay, if you're 58 and you're a man, you probably have another 30 years to live. So sometimes the jury can rely on that. But if you've got a plaintiff that has a decrease in life expectancy because of the injury, for example, they're in a vegetative state, then you are going to need someone to testify to the life expectancy, because obviously that's going to impact the future medical specials that they can recover. The admissibility of the billed or undiscounted amount, the courts have been going back and forth a little bit on this one. Corning-Baum, which came out in 2013, I love that decision. Essentially, they said a bill from a hospital is evidence of absolutely nothing. And it's not, because you've seen the bills. They're all different. Everybody's $5,000 for an MRI. It's $2,500 for an MRI. But it's on, but the carrier that private insurance carrier will maybe pay $500 or $750. So essentially, what Corning-Baum said is it just doesn't come in at all, because it's not reflective of the value of the services received. But now what has happened is that if the plaintiff is uninsured and there's nothing else out there, if the plaintiff's attorney hires someone to say, okay, this big, huge, fat bill actually does reflect reasonable value, then it appears that billed amount can come in. And there's been different decisions in different appellate courts. So it's probably going to depend on your jurisdiction whether the whether the undiscounted billed amount will come in or not. But you should definitely fight ferociously to keep that information out based on what I discussed at the very beginning of the presentation, because that will definitely increase the amount of the ultimate verdict. At trial, the treating physicians should be there to testify that the treatment was required as a result of the accident, and also to testify about any future treatment and the reasonableness of charges. Again, if they have an expert up there, we had a case where it was complex regional pain syndrome, and this guy was the expert from La Jolla, and he was estimating, cost until she died of about $75,000 per year. And the judge, before he testified, he said, we need to do what's called an evidence code 802 hearing. I need to know that this guy actually has background on what this kind of stuff costs. And the judge wouldn't allow me to do that. But you need to ask for an 802 hearing to make sure this provider or hired gun actually has some background or experience in what the different treatment costs before he's allowed to testify. Because you gain a big advantage if somehow the judge just says, you don't know what this stuff really costs, and doesn't allow that person to testify. Medical records, you need to be careful. I think a lot of plaintiffs' attorneys think that they can just go to trial and then they'll just bring in the medical records and the bills and hope the jury will determine that it was all related to the accident. They can't do that. In the past, there was always a presumption that the medical doctor had to come in order for the records to come in, but now the court has allowed that there can be an affidavit by the custodian of records, and those records are admissible, but not all parts of the record. So make sure that you see whatever the plaintiff is planning to introduce and that you object on hearsay grounds to anything in the medical records that is not going to be testified to by a witness at the time of trial. For example, a lot of times they'll try to get in the opinions of the medical provider, but if he's not there to testify to those opinions, then the retained expert shouldn't be able to talk about the opinions or conclusions reached by the medical provider, because we're not there to cross-examine the medical provider as to his opinions. And we don't want the retained expert's credibility to somehow be increased if it's consistent with the medical provider's opinion. So now based on everything we've said, there's a situation where, this is a recent case that came out, the plaintiff had no medical insurance, and she contracted with the medical providers to treat her in exchange for a lien on whatever she might recover in the lawsuit. Medfin purchased the lien from the medical provider at a discounted amount, but the plaintiff remained liable for the full amount. The defense tried to exclude the amount of the full billed amount, but the court let it in. And then what was at issue is whether whatever Medfin had paid to the medical provider came in. And the court decided that whatever the financing company had paid, it was relevant. But in this case, it was not admissible. And those are two separate things. Again, we've had a case that we've been fighting for a year to try to get this number that the financing company paid, and they just fought us tooth and nail. And finally, we've got a decision where they've said, yeah, this is relevant, what the financing company actually paid. But in this case, the defense didn't tie the amount the financing company paid with an expert to say, oh, the amount the financing company paid is reflective of reasonable value. And based on that fact, the court said, we can't let this amount come in, because when a financing company is determining how much they're going to pay the hospital, they're not there might be some aspect about whether it's a reasonable value, but what they're looking at is, hey, am I going to be able to collect this debt? Did this guy get rear-ended versus some other case where there's disputed liability? So that figure that the financing company pays to the hospital can have absolutely nothing to do with the reasonable value of treatment received. So I understand that, but as long as you tie it together, you have an expert to say, no, it is reflective of the reasonable value, then you should be able to get in the amount that any financing company has paid to the hospital. But in this case, they decided it was just too prejudicial and too dangerous because the jury might assume that the amount paid did reflect reasonable value. So it was left out in the Uspenskia case. And now this is the case that I was talking about earlier, and the firm that may have been engaged in questionable conduct is, it's not important who the plaintiff's firm is that's trying to pull this stuff off. It's not important what doctors may be involved in these types of situations. That's not important, and I don't want you to concentrate on that. But again, essentially what happened, this gentleman's involved in a rear-end accident. He's got Kaiser health insurance. His attorney refers him to a certain doctor. It's not important who the doctor is. And the doctor provides him with spine surgery at John Muir Health. And like I said, the cost billed ended up being like $280,000. And the guy signed a lien with the financing company where he's paying these exorbitant fees on the amount that he's supposed to be paying to the financing company. And the financing company, of course, is saying, no, you're responsible for the full amount. We're never, ever going to discount it. So what happens in this case where he's got health insurance, but he went outside his health insurance? And what comes into play is the duty to mitigate. You have to mitigate your damages. You can't purposely increase the amount of your damages. And in this case, if he had gone to Kaiser, he wouldn't have had this huge lien, and he wouldn't be paying interest on this lien. And why should we be responsible for the decision that he's made? And it's not where you want to reward him because he's been paying insurance premiums. It's this guy just made a stupid decision, probably dictated by his attorney, to go outside his health coverage to receive treatment. So we know that the amount paid is relevant to the reasonable value, so we should definitely be able to bring in the fact that $70,000 is what was actually paid for this medical treatment. Right now, it's questionable whether the amount billed is going to come in. If the plaintiff hires someone that says, oh, yeah, this is reflective of the reasonable value, then they probably get that $280,000 bill in. And what the issue here is, they may say the it's actually Infinity Management Capital is the financing company. They may say, oh, that doesn't come in, that's a collateral source. But it's not a collateral source because, as I mentioned before, it's not something where the plaintiff was responsible in paying insurance premiums, so they shouldn't be, they shouldn't receive less money because they've been responsible. In this case, the gentleman voluntarily decided to enter into a financing agreement with another company. And he wasn't forced to do that because he had health insurance. So it's a little different than the Kaczynski case that we looked at earlier. So it's very interesting to see, it will be very interesting to see how that case turns out. And we just got set for trial in July on that one, so we'll figure it out. So to figure out evidence to show that they failed to mitigate their damages, you need to do Form Interrogatory 4.1, and that's when the plaintiff is supposed to identify any type of insurance they have that might cover the damages that they've suffered in this case. And sometimes you have to follow up because they always kind of say no, no, no. So maybe a specific interrogatory saying, did you have any health insurance at all when this accident happened? You should serve a request for admissions, as we did in our case. Did you have health insurance through Kaiser? Yes, I did. Were you referred to Dr. XYZ for treatment? Yes. And your attorney referred you, correct? Yes, my attorney referred me. And then what we do is we deposed his treating physician at Kaiser and said, hey, if he wanted to get this surgery at Kaiser during this time, could he have gotten this surgery? Oh, yeah, of course he could have. We provide those services here. Do you have any idea why he didn't go through Kaiser? No idea. I don't know why he wouldn't have gone through Kaiser. And the game the plaintiffs play is they say, oh, I'm entitled to get medical treatment anywhere I want. And that's fine. I understand some people may have issue with Kaiser or other medical providers, but the fact is that the defendant doesn't have to pay more in damages because of your personal decision as to where you're going to receive treatment. They have to mitigate their damages. So in that type of situation, what we'll probably do is we'll have Tammy Rockholt look at what Kaiser might have billed for this type of treatment, and then also, compare that to what John Muir ended up charging for the treatment. But again, trying to push that incurred amount, the amount that was actually paid by the financing company, which is actually the amount that Tammy Rockholt came up with as being the reasonable value of treatment. So our hope is that the jury will again hook into our $70,000 figure instead of the $270,000 figure, and that it will significantly reduce any verdict that might be reached in the case. That is the end of my presentation. So I apologize, I threw a lot at you at once, but I know we've got an experienced group, and if you do have any questions, I will be at the bar after this is all over. So feel free to come and ask me any questions you might have. Thank you.